Hello, my name is Stuart Richland. I've been a lawyer for 25 years here in Southern California, representing medical marijuana collectives, co-ops, dispensaries, patients, etc., for about 6 years. And I've had the pleasure to have represented hundreds and hundreds of medical marijuana collectives and thousands of patients with very good success in court, and also with reference to litigation, which sometimes occurs with the local municipalities, etc., with reference to challenging the law, and also with hearings before legislative bodies. Whatever your needs are with reference to the law, I'd be very honored to be of service, and if it's not something that I do, to give you a great referral to someone in my network of colleagues who knows how to handle that area perfectly. With reference to medical marijuana, my main service is the consultation. It's here in my office in Hollywood. It includes my book. My basic book is a $500 souvenir of our $500 meeting. It's a 1-hour meeting. The book, though, itself is nothing without the talk, and the talk is really nothing without the book. The book is intrinsic because it is full of examples that I use to show you how medical marijuana law works. Some of them are reprints from the law, like this happened to just jump to, the guidelines from the Attorney General's office here in California, and other things that are from official sources. Here's something from the State Board of Equalization. And then here's my comic book, constantly updated, which contains information in a visual form, a format that allows different people to absorb information at different speeds, at the highest speed possible. And in the hour, I think you'd be amazed at the number of data points that I can cover with reference to medical marijuana law. Those patients that wish to then go on to form a nonprofit, I have this little upsell for them. It's $1,000 more, and it's another book about how to create a nonprofit mutual benefit corporation, and then a beautiful corporate book that contains all of that material. So we want you through here as soon as possible, and then I can also explain to you, in addition to the individual defense and the collective defense, how the caregiver defense works. And the caregiver defense is really very important nowadays, because even the federal government's recent memo and even the taxation handling for caregiving services is very favorable. So although federal law still says medical marijuana is a felony to grow or to sell or to distribute, there are definitely strong state defenses. Patients can possess, transport, and use their own medicine, whereas they can only do activity on behalf of someone else if they have a special relationship to that person, such as the relationship of a caregiver or the relationship of a cooperative or collective. We go into all of this information in our 1-hour talk. In addition, we also go into city law and county law, the local aspect of law. So there are 3 main topics: federal, state, and local. And you'll see that the information that I present is highly visual, and I use tools such as my little colored marker and tab set to make sure that your book is fully marked up so that you can recapitulate the meeting on your own and study the law as you wish to at home. Well, the way to get a hold of us here is to call 888-420-LAW-1. That's 888-420-LAW-1. My office is in Hollywood, right underneath the Hollywood sign near Melrose at Cahuenga. And the address is on the site. Well, thank you very much for touching base, and I look forward to being of service. Here is Representative Polis questioning the Attorney General, Eric Holder.
The issues surrounding the regulation of medical marijuana. I wanted to first clarify that there's a memo dated October 19, 2009 from David Ogden. I'm sure you're familiar with that memo. The contents of that memo as advisory to the states is still in force. Is that correct? That is still a current memo?
Yes.
Okay, thank you. And one of the issues that was later clarified in a memo by James Cole is what we're talking about when we're talking about caregivers, who your memo instructs should not be an enforcement priority. The Colorado Constitution in Article 14 happens to have a definition of caregiver. It's further refined in our Colorado statutes. And I wanted to see whether I can get your assurance that our definition of caregiver in our state's Constitution will be given some deference by the U.S. Attorney General's office.
I'm not familiar with the provision, but what we said in the memo we still intend, which is that given the limited resources that we have, and if there are states that are that have medical marijuana provisions, and if you take into account the Cole memo, if in fact people are not using the policy decision that we have made to use marijuana in a way that's not consistent with the state statute, we will not use our limited resources in that way. And so
Sure.
I don't know if I assume that I just don't know about that provision.
And again, yeah, in the case of Colorado, we do have definitions of some of the terms in your documents in our Constitution, and I would hope that the U.S. Attorney General for the state would look at that. Now, as you know, the Department of Justice recently announced a crackdown in California. Now, part of the issue there, it's my understanding, they did not have a functional state-level regulatory authority. Colorado does have an extensive state regulatory and licensing system for medical marijuana, and I'd like to ask whether our state regulation, our thoughtful state regulation passed with strong bipartisan majorities in both chambers of our legislature, provide any additional protection to Colorado from federal intervention.
Well, again, I'm not familiar with it, but I have to look at it. But again, our thought was that where a state has taken a position as it passed a law, and people are acting in conformity with the law, not abusing the law, but acting in conformity with it. And again, given our limited resources, that would not be an enforcement priority for the Justice Department.
Thank you. I'm grateful for that clarification. One of the issues that many of the legal, regulated medical marijuana shops and dispensaries in Colorado have brought to my attention is their inability to open bank accounts at most FDIC institutions. That makes the industry harder for the state to track, to tax, to regulate. And in fact makes it prone to robberies because it becomes a cash business as well. Is there any intention of the Department of Justice to prosecute bankers for doing business licensed and regulated medical marijuana providers in the states?
Again, I would think that consistent with the notion that how we use our limited resources, again, if the bankers, the people seeking to make the deposits are acting in conformity with state law, that would not, again, be an enforcement priority for DOJ, for the Justice Department.
Thank you.